joining. Today we're going to be recapping a lot of human rights, mainly human rights, because most of you guys would have just finished or will be coming to the end of human rights. So I thought, why not recap it and go through kind of revision for it. I know some schools do human rights first and then crime, but I'm just going to follow the order of the syllabus. So if you don't know who we are, HR Notes are, basically we're an organization that's devoted towards giving you guys free or very low cost resources like these lecture series that are completely free. We have a range of different resources that we offer, not just the lectures, things like notes as well, videos. We have a forum that I'll talk about in a second. But yeah, that's who HR Notes are. These are some of the free resources that I was talking about, completely free, some things to check out for sure. So we have our study notes, which I would definitely recommend for legal studies, because you can take cases and statistics and a lot of evidence in general from other people's study notes. So it can really, really help you. We have these lectures. Obviously, you're here today with me. We have our discussions and our online kind of forum page. Now, I have mentioned this in kind of my lectures I've given before, but I'm going to repeat it today. I would really, really recommend using the online forum for a multitude of things, asking for help, connecting with your peers. But the number one thing that I personally used it for, the forums, was getting feedback. My teacher was, because of the amount of essays I would give, he was kind of bombarded with a lot of my writing, and it was a bit hard for him to get through all the feedback I was awaiting. So what I would also do is post my practice responses to the forums and ask for feedback from past HSC students who had achieved well, and my peers. And it actually really, really helped me. Especially people would say things like, hey, in my class we studied about this case study. I think it would really work with your argument. What about this statistic? I'm wondering if you could have also said this. And it was just, overall really, really good. That's something that I can definitely recommend using the online forum for. And I will always be a lover and a number one fan of the forums for that reason. We also have some videos. We have our newsletter. We have an ATAR calculator, which of course take with a grain of salt, because ATAR calculators, of course, no matter where you go, it's never going to be 100%. But I do know, because I was once a Year 12 student, I know that as you go through Year 12, you progressively look at ATAR calculators more and more. But yeah, take it with a grain of salt is what I'll say for that. Because I remember some of the scores I would put in, I would be like, that's it, I'm going to fail, I'm going to get a 20 ATAR, it's going to be horrible, and it didn't end up like that. Articles, we have some great articles to check out. We have them for different subjects, so I would definitely recommend the ones for legal studies. And yeah, we have heaps more, okay? Heaps of different free resources. I would just recommend going onto our website hrnotes.com, and checking them out. But yeah, overall, the one that I'm really going to hone in on is the forums, because that's the one that I'm kind of biased towards, because I loved the online forums. Okay, special thanks to the organizations and the unis that have supported these lecture series and help us run them today. Okay, so I'm going to quickly introduce myself. I'm Chloe Lee. It's nice to meet you all, even though I can't see anyone. I guess I'll be in the Slido answering your questions, so that I will at least be having some degree of interaction with you guys. Hopefully some of us have met me before, because I have run some legal studies lecture series earlier in the year, and even in Year 11. So maybe we've met me before, maybe we haven't. Either way, I'm Chloe Lee. I graduated in 2021. I got a Band 6 in legal studies. I loved legal studies. It was my honestly, one of my favorite subjects, either legal studies or biology. I had a great teacher for legal studies, and that's always like half of it, how good your teacher is. Right now, I'm currently studying medical science at UNSW, on path to study postgraduate vascular sonography. So I was very Englishy in Year 11 and 12, and I kind of flipped it and went to towards like medical science and STEM, and yeah, completely different. And I'm studying at the University of New South Wales, Sydney. Okay, so this is the game plan for the next 2 hours together. We're going to have 4 content blocks. 3 of them will be on content. The final one will really just be about frequently asked questions about legal studies and about human rights that I get kind of every time I give a lecture, so I'm going to tackle those. But in terms of the content blocks on the content, we're really going to be going through human rights, okay? The nature and development of human rights, promoting and enforcing human rights, and a guide to smashing the human rights section of your exam. Okay, so these will be kind of the areas that we are covering today. So as I said, the nature and development of human rights. So that's looking at the definition of human rights, the developing recognition of human rights, the formal statements of human rights, and these kind of criteria for each of those. Now, please see the October and January lecture series, which is available on atarnotes.com, for crime. We're not going to be covering crime today because we've already had lectures on crime, and you can just go and revisit those. So today we're going to be looking at human rights together. And then content block 2 will be on promoting and enforcing human rights, as I said. So that's looking at state sovereignty and the roles of different institutions, bodies, governments, non-legal responses to the promotion and enforcement of human rights, their responses to. Okay, and then we'll be looking at Australia in particular and how it protects human rights by both promoting it and enforcing it. All right, so, and then, yeah, we'll have our How to Smash Human Rights short answer section, which will include knowing what to include in your response. So how many pieces of legislation, how many case studies, how many media articles, how many lines should it be, etc. We'll look at using your time effectively and nailing the execution of an answer. So articulation, conciseness, all that good stuff. All right, so today I wanted to just kind of say this because I know obviously we're going to be doing a lot of revision today, right? So we're going to be doing a lot of maybe note-taking or at least writing down in some way. But I also want this to be an opportunity for you guys as we go through today's lecture to think to yourself, okay, when she spoke about that area, I kind of got it, but maybe I need to rewatch this lecture and re-listen to Chloe explain this again. Maybe I need to go back to my notes and really remember the stuff we went through in class. Take note of the areas that you are really, really confident in, and as I'm talking, you're going, yep, I understand all of this, and the areas you're kind of learning maybe for the first time or picking up the pieces as we go along. Maybe that might mean highlighting every topic area that you don't understand, putting a star next to it, whatever it may be. Think about where your strengths and weaknesses lie. Also, ask questions and seek clarification, okay? So below my video that you're watching now, there'll be a Slido. For those of you that have come to my lecture series before, you know that there's that Slido, but really ask questions if you need any help or if something doesn't quite make sense, or really any question you have about legal studies, the HSC, university, whatever it might be. Pop it down there, and I'll answer them as we're kind of going through the lecture today. Take notes, as I said, but make understanding the content your priority. So if you find yourself taking notes, but you're not actually listening to what I'm saying, or you're not actually understanding it, pause from taking notes and just listen, okay? Listen and actually try to grapple with what I'm saying, because you might have the notes, doesn't actually mean you're understanding anything that I'm talking about though. All right, so let's begin topic 1, which is the nature and development of human rights. So, let's look at the definition of human rights. According to the OHCHR, which is the Office of High Commission for Human Rights, human rights are inherent to all human beings, whatever our race, nationality, place of residence, sex, ethnic origins, religion, language, or any other status. We are all equally entitled to our human rights without discrimination. These rights are universal, inherent, and inalienable. Okay. So, do you need to say all of that if you're asked to define human rights? No. Really, all you need to say is human rights are inherent to all human beings, regardless of status. Because I think, yeah, any other status, all this kind of stuff is covered by status. Yeah, they're inherent rights that belong to all human beings, regardless of status. Something like that will cover it. But the biggest thing that I want you to remember is this idea here. Human rights are universal, inherent, and inalienable. Okay, please don't forget to mention those if you have to define human rights. I see this come up a lot in multiple choice. It'll say something like, human rights are, which of the following is human rights not? Universal, inherent, inalienable. Let me think of something that human rights is not. Divisible. Okay, and you'll have to say, yeah, it's not divisible. You can't divide, these people have these human rights, but that doesn't apply to these people. No. Yeah, so it's really important that when you define human rights, you define it by saying something like I was saying, human rights are inherent to all human beings, regardless of status. They are universal, inherent, and inalienable. That's really important as well. Okay, yeah, as I was saying, those are the three kind of big things. Cool. Oh, to go through each of these, the universal, because it applies to everyone all around the world, no matter who you are. They're inherent because you're born with it. If something's inherent to you, it's inexplicable to you. You can't detach it from yourself. It's a part of you. So it's not like you're born and then you have to work for your human rights. No, as soon as you're born, you have human rights. And it's inalienable because you can't alienate certain people from human rights. As I said, you can't say, we have the right to shelter, but no, you guys, everyone has the right to shelter. Okay, so in order to understand what human rights are, or what they mean, we must first understand how they evolved historically. Okay, so let's first look at the Magna Carta. The Magna Carta was kind of the first big document that in some way recognized human rights. Okay, so in 1215, the Magna Carta was published, and it basically stated that the king, or the sovereign crown or state, or the monarchy in general, is subject to the rule of law. This might not sound like a big deal, but you have to remember, at the time, the king was seen as second to God. Okay, that's the first thing, following the Christian faith. And then the second thing is that because of that, anything the king did was it had to be respected. Okay, the king beheaded someone, because of their close proximity to God, no one can kind of contest that. So this was the first time we saw, even the king is subject to the rule of law. All of the law that we have also applies to the king. The king can't just freely breach laws. Okay, so it was actually a really big, important step towards the recognition of human rights. So the Magna Carta imposed significant legal reforms, but it also came to symbolize principles of equality and accountability. For example, Clause 39 introduced the idea of no man being imprisoned without due legal process. Okay, so the Magna Carta gave rise to the protection of other human rights. And it also helped people to realize a fair system of human rights is within their grasp. Okay, so copies were distributed widely to every country court in England, and it was translated into the local vernacular. Okay, so it's these are kind of the three main principles of having a successful humanitarian government or society. We need democracy, liberty, and accountability. Okay, and the Magna Carta started to introduce those principles. Okay, also, something that you might see in multiple choice is that human rights can also be referred to as, yes, inalienable, inherent, universal, but also the fourth one is indivisible, okay? Not to be confused with divisible, as I was saying earlier about dividing. It's the opposite of that. Human rights are not divisible. They're indivisible, therefore. You can't say, okay, only some rights apply to you, but others don't. Okay, they're indivisible. Why am I mentioning this? Because sometimes in, multiple choice, they'll say what is not a feature of human rights: inalienable, indivisible, inherent, illegal. Okay, and you'll think, okay, but indivisible was one of the three that I learned about. It's almost like the fourth one. Okay, you can also mention it in your definition. You wouldn't be marked down at all, but it's not one of the big threes that was in that definition that we looked at earlier. So in other words, all rights are equally important. Okay, so I can't say these are the human rights I have, however, I don't really have these human rights. It's a big misconception that the government gifts you with rights. Okay, obviously the government does not gift you with any rights. You are born with them. Unfortunately, the government can choose to not respect those human rights. It doesn't mean that you don't have human rights. So for example, we know we have a lot of breaches of human rights in China. That doesn't mean that the Chinese population doesn't have human rights. They do have those human rights. They're just not respected. Okay, because as it says there, they're a birthright. As I said, some countries don't recognize human rights as they believe the state has the power to award them, which is a big misconception in many different states. Okay, now we're going to look at the next kind of syllabus dot point now that we've defined human rights, and we're going to look at the nature and development of the following human rights. So the way that this syllabus dot point will be asked to you is likely you'll be asked to kind of recount the history of the development of one of these rights. What does that actually include? It includes stating events and the effects of these different events. Okay, so I would be listening up, and if you're someone that's making notes, I'd be jotting down each one of kind of the key events in each one of these, the history of each one of these human rights. Okay, so we'll begin with the abolition of slavery. Okay, the modern world was built off the back of slavery, including the Roman Empire, ancient Egypt, and the slave trade. Okay, this sounds kind of crazy to say, but back in the times of the Roman Empire, ancient Egypt, and the slave trade, especially the first two, it was kind of just, we need slaves for society to run. We need slaves to kind of make society function and for all of us to live. Slavery was not seen as immoral. It was more seen as important or necessary for society, which sounds crazy because we know obviously slavery is deeply immoral, but at the time it was not viewed like that. Okay, which obviously is very unfortunate because that meant many groups of people's human rights was just, being exploited and disrespected, but that was the belief back then. So over time, okay, especially during the 1800s in particular and the late 1700s, we had big pushes to abolish slavery, okay, because of its nature, its kind of evil nature. So in the US, Abraham Lincoln's Emancipation Proclamation was the big one that basically freed the slaves, okay? But only in states rebelling against the Union would be free, okay? But it was still a kind of a really big document in working towards the abolition of slavery, okay? Abraham Lincoln's Emancipation Proclamation. We also have the Society for the Abolition of the Slave Trade, which kind of kept advocating for further abolition of slavery and obviously the slave trade and putting pressure on the US and other states to abolish slavery in its entirety. Now, remember, when we say states in human rights, I don't mean Queensland, New South Wales, Western Australia. I mean states as in countries, okay? Remember that. So every time I say states, I mean countries. Nation states, right? States. So how did the society actually do that? Well, it wrote books, it produced posters, and it toured around English cities kind of advocating for the abolition of slavery. So if you're asked to recount the development of the abolition of slavery through time, I would probably start with talking about the idea that kind of ancient civilizations or prehistoric, ancient, older civilizations that no longer exist held the belief that slavery was necessary for society's function. However, during the 1800s, there was a change and it kind of catapulted into Abraham Lincoln's Emancipation Proclamation, which was the first document that in some way freed slaves and worked towards the abolition of slavery. Now, slavery still exists, okay? When you're talking about the developing recognition of slavery, a big thing that I see in students' responses that I'd like to clarify is please don't say that slavery doesn't exist anymore. Unfortunately, it does, okay? But the thing you must say if you're talking about slavery, listen up, the thing you must say is that while slavery in its traditional form does not exist in such large numbers or in such an acceptable way as it once did, slavery still exists just in a different form. It has a different face, okay? There are still people that are in, shackles and in dark places and never see light. I'm sure that still does happen. But the most common form of slavery in the modern age is slavery not in its common form, okay? Things that don't look like someone in shackles in like a dungeon and, they never see the light of day. It's more so things like sex slavery, okay? Or human trafficking or sweatshop workers. Sweatshop workers, they can go home. A lot of them do go home. You could argue that it's work, so they're kind of asking to be there. Very hesitant to say that because that's often not the case, that they just want to work. But that's still slavery, okay? Why? Because some of them don't get paid at all, or if they do get paid, it's very, very little compensation for the strenuous amounts of labor that has to go into sweatshop work, okay? And that's slavery. So the idea here is if you're answering a question about the development of slavery in particular, is you need to make mention that slavery has changed its form, shape, face, okay? And to prove that slavery is still in existence, you can refer to the Global Slavery Index 2016, which estimated that there are 40.3 million slaves today. And I'm going to argue, that number is very much below what it probably is. Why? Because we have no database of reporting slaves. We don't actually, there's no way to actually count how many slaves there are. That's just an estimate. So there's probably, unfortunately, a much higher number of slaves still in use. Okay, so modern responses. This is something also that you must talk about. We have UDHR Article 4, which states that no one shall be held in slavery or servitude. Slavery and the slave trade shall be prohibited in all their forms. We have the ICCPR Article 4 that states no one shall be held in slavery. Slavery and the slave trade in all their forms shall be prohibited. So you can see it took straight from the UDHR. We have the Australian-based Walk Free Foundation, which is a non-legal response to the 30 million people living as forced labourers, forced prostitutes, child soldiers, child brides in forced marriages, and as pieces of property. And then domestically, another domestic response. So in Australia, we have Section 270 of the Commonwealth or the Criminal Code Act 1995, Commonwealth, also known as the Commonwealth Criminal Code Act. It defines slavery and all its forms and outlines it in statute. And it states that it's prohibited in Australia, obviously, and it's derived from the Slavery Convention 1926. Okay, so we have international responses there, the UDHR and the ICCPR, and we also have some domestic responses that you should also be including both of these in a response about the developing recognition of the abolition of slavery. Okay, R versus Tang. Okay, R versus Tang, hopefully we're mostly familiar. Hopefully this is revision. Maybe it's not. But in R versus Tang, we had Tang, who was using prostitutes in a brothel in Sydney. And what basically she had done is she had gone over to Thailand and met with a bunch of women and basically said to them, yeah, you'll come work for me in Australia. You can come live in Australia. You'll have a good life. You know, come over. It'll be fine. She brought them over illegally. And then when they got here, she held onto their passports and said, you need to work for me now. I'm not letting you go. You can't leave work. You need to work for me and, be a prostitute and work. And as I said, held onto their passports. She threatened them and said, if you choose to leave, I'm going to go straight to the police and I'm going to tell them that you're here illegally. Okay, so obviously they were terrified and didn't want you. So that's slavery, right? They had no choice but to work. So obviously she was convicted. Okay, she was found out and she was convicted. And why is this such a seminal, such an important case? Because it was the first successful prosecution of slavery in Australia. Okay, in 2008. She was convicted under Section 270 of the Criminal Code Act, as I mentioned before, and she was served or sentenced 10 years imprisonment on 5 counts of possessing slaves and 5 counts of limiting movement between Australia and Thailand. This also links to transnational crime, so you could also use this case in crime as well. Okay. Now, moving on to trade unionism. Okay, so moving on from the abolition of slavery. Okay, so labor rights. What are labor rights? And we're going to go into this more in a second, but labor rights are effectively your rights as a worker. Okay, so things like not working 20-hour or 16-hour days like we had in the beginning of the Industrial Revolution, not working in unsafe conditions, being properly trained if you need to lift things or work heavy, complex machinery, being given a proper wage, all those kinds of things. Those are your labor rights. So what is a trade union? Well, to give you a bit of a backstory to this, effectively, we'll talk about in Australia and in New South Wales in particular, we had at the beginning of the Industrial Revolution a lot of factory workers, okay? And these factory workers weren't kind of modern day factory workers. They didn't have a lot of, or many at all, labor rights. So they were working in extremely unsafe working conditions. Children were working. We had long 16-hour work days, very low wages, okay? So obviously, they were able to recognize it and they were unhappy with it. So what they would actually do is after work, they would go to their local pubs and they would all meet up, and you can imagine they would start to have a little bit of a drink, and then as they would become more intoxicated, they would get more angry and more angry and more angry. And what actually ended up happening as a product of those meetups between the workers is they kind of started to band together and start to realize that, well, if all of us don't like our conditions, I can't go by myself to my employer and say, you better give us all equal pay. We better have more money. We don't want to work 16 hours. We don't want our children to have to work. Obviously, the employer is just going to look at them and say, all right, you're fired, and then hire someone else who wants or really needs a job. But they realized that if they all banded together and they all went to their employer and said, we're all going to leave unless you give us equal pay, pay rise, shorter work day, whatever it is, the employee is more likely to listen, okay? Because imagine you're an owner of the business, or your employees just want to up and leave. You would kind of be like, oh my gosh, okay, I need my employees, I need to listen and hear them out. So that's where this idea of a trade union started to form. A lot of you probably work in retail or maybe at Macca's or something like that. And maybe you've had union workers approach you, maybe you've even joined a union. So you would probably know that a trade union is established to protect your rights as a worker. Okay, so from those banding together at the pubs, we started to form actual organizations that would represent different industries. Okay, we have the Maritime Union, we have different retail unions that represent retail workers. we have a range of different unions, okay, for almost every industry. Okay, so a trade union is an organization formed by workers that may campaign on internal work-related issues such as pay or working conditions, as mentioned. They also sometimes campaign on broader social and political issues too, for example, global warming or political conflicts, yes. If let's say a factory is emitting a lot of CO2, the workers may protest against the business to be more environmentally conscious. It emerged, as I said, as a result of the Industrial Revolution in response to appalling conditions. So, why did I tell you all of that? Not just for story time, but also, again, for the nature and development. Okay, if you were asked about the development of trade unions and labor rights, that's what you would want to be talking about. In the beginning of the Industrial Revolution, workers' rights or labor rights were appalling. They weren't respected. However, they started to band together. You probably don't need to go into the fact that they would meet up at pubs and drink and then get angry and band together. You probably don't need to mention that. You can probably just mention the fact that they would kind of band together and then negotiate for better rights or better respecting of those rights. Okay, so as I mentioned, workers wish to address the imbalance of power between the employer and the employee by combining to form unions, modern responses to labour rights. We have the UDHR, Article 23, Section 1, 2, 3, and 4, which outlines the protection of labour rights. We have Article 24 of the ICCPR. We have the Australian Council of Trade Unions, ACTU, which is the peak body representing 46 unions in this country. So basically, we have a range of different trade unions, and then it's all covered by the Australian Council of Trade Unions, okay? We have a bunch of different unions under one big body. We have union movement in Australia, which led to the formation of the Labor Party in the 19th century. Okay, so yeah, trade unions literally gave rise to the Labor Party in the 19th century. All right, so the achievements of trade unions. We have minimum wages now, and we have much better working conditions than in the beginning of the Industrial Revolution. We have the 8-hour workday instead of the 16, 20-hour workday. We have equal pay for women, or at least we're getting there a little bit. And everyone that's working full-time should have paid 4 weeks leave. Okay, so we have achieved some things with trade unionism. Actually, we've achieved much. Okay, if you compare it to the beginning of the Industrial Revolution, it's significantly better. Okay, now moving on to universal suffrage. Universal suffrage and self-determination is always confused by students. I'm not sure why, but let's first begin with universal suffrage and we'll differentiate it to self-determination. So universal suffrage is the right to vote for everyone. Okay, universal suffrage is the right to vote for everyone. Every adult citizen who's competent to. Okay, children obviously don't vote. It wouldn't make sense for a 2-year-old, 3-year-old to vote. It's every adult citizen. Okay, the right to vote was originally confined to males, and specifically males who owned land. Okay, so if you again are asked a question about the nature and development of universal suffrage, I would say that at the beginning of the 20th century, or the beginning of the 19th to 20th century, only men, specifically men who owned land, were able to vote in many states. However, in New Zealand, in the beginning of the 20th century, New Zealand was the first state to have women given the right to vote. But that was at the beginning of the 20th century. Throughout the 20th century, we continued to have a push for everyone to get the right to vote, which is known as the suffragette movement, okay? It was a non-legal response to try and gain suffrage for women, and not only women, but Indigenous peoples. Particularly in Australia, we had in 1962, Indigenous peoples given the right to vote. So universal adult suffrage was achieved because everyone in Australia was given the right to vote. Okay, modern responses that cover universal suffrage. We have Article 21 of the UDHR, Article 25 of the ICCPR, and it's implied in the Constitution as well. It's an implied right. Okay. In 1844, the New South Wales Legislative Council conducted an inquiry into education and found that only 50% of the children aged between 4 and 14 received an education. Okay, so now we're moving on to the right to universal education. So if you're talking about the developing recognition of the right to an education, I would start with that statistic there, that in 1884, it was found that only 50% of children between 4 and 14 received an education. Education was only available to the aristocracy, but during the 18th century, the percentage of the educated population began to widen. Okay, so only the bourgeois or the wealthier members of society were given an education. In France and Germany, the government started to fund schools, so the idea of a public school was born. The gradual widening of suffrage during the 1960s and 70s helped to achieve universal education because it became recognized that people need to be educated in order to vote. Okay, the biggest thing that protects universal education in Australia is that act there, Public Instructions Act 1880. That act created public schools. Okay, it created government-funded schools and schools that were secular, meaning non-religious, because before that, largely, all the schools were Catholic or Protestant. Okay, so it created secular schools that didn't follow any particular religion, and they were government-funded, meaning that your parents did not have to pay any school fees for you to attend school. This was incredible, okay, for the Australian population because it obviously gave everyone the right to an education, or at least protected that right, but also it helps protect other rights, like universal suffrage, okay? As I just mentioned, you can't vote unless you're really educated on the matter. Otherwise, you're not really voting, are you? You might be writing on the ballot paper, but are you really actually voting? Yeah, that's up to you to define, but you can see that we need universal education for the protection of other rights as well. And a big thing is education is how you become aware of your rights. So if you're not educated, you might not even know that your rights are not being protected. So that's domestic legislation, or at least in New South Wales. Then we also have international instruments that protect universal education. So we have Articles 13 and 14 of the ICSCR. We have Article 26 of the UDHR. We have Articles 28 and 29 on the Conventions on the Rights of the Child. Today, we have state government schools that provide preschool education, compulsory schooling from kindergarten to their 17th birthday, and senior secondary education for years 11 and 12. Yes, something that I didn't mention is in this piece of legislation, schools weren't only secular and free, they became compulsory. So people now, or students or children, now needed to go to school, whereas before it was optional, and particularly optional for those who could afford it. The cost of tertiary education is offset by a system of loan repayment, so HECS, encouraging further education for Australians. So when you get to university, some of you, probably most of you, will use HECS, which is basically like a loan that you don't pay interest on that covers the cost of university while you're studying it. So you don't have to pay for your university fees to study. And that makes university significantly more accessible for students. Regardless, 130 million children aged between 6 and 11 are still denied basic education internationally. Yes. So if you're asked about the nature and development of education, universal education, I would be stating the history in Australia and how we now have achieved universal education, but still acknowledging that globally it's still a significant issue. We have many different countries where universal education has not been achieved, such as Saudi Arabia, South Sudan. Those are the two countries that come to mind, only because those are those are the main two I looked at when I did this in my Year 12 study. But there are unfortunately a large number of states that deny women in particular a right to an education. Okay, so this is self-determination. It's the right of people to freely determine their political status and freely pursue their economic, social, and cultural development. Okay, so it's basically people's rights to freely assert their sovereignty and political status. It's a collective right, okay? It's not an individual right. Why? Because you can't just have self-determination. You can't just govern yourself. You need a group of people to govern. That's the idea, that you on your own can't have kind of like a political status, but it needs to be a group of people who share a political status that needs to be protected. That's the idea of self-determination, not to be confused with universal suffrage. Universal suffrage is about voting. Self-determination is about people being able to govern themselves and their own land, particularly Indigenous people, okay? So what we had in the history of modern day civilization, we had colonization of many different states throughout the world, okay? Particularly by French, Italians, Spanish, English. A lot of kind of those countries were the big colonial powers. So what ended up happening at the end of the 18th century into the 19th century, into the 20th century, is we had these colonized countries that they didn't have, for example, like the Philippines. Philippines was colonized by the Spaniards, or the Spanish, and we basically had the idea of empires or big colonial powers living in and controlling states that they did not have the right to. So we had the process of decolonization throughout the 20th century that basically removed their power from the states that they were kind of seizing at that time. So the Philippines regained power. Different states that had been colonized by these colonial powers gained their power back, which was obviously a really good thing, right? That's self-determination. They're able to regain government control of themselves and their land and make decisions about themselves. Unfortunately, this hasn't been the case for Indigenous Australians. Self-determination hasn't really at all been achieved for Indigenous Australians. Another thing, the Treaty of Westphalia shifted countries away from imperialistic rule and towards a nationalist identity, which is what I was talking about, right? That period of decolonization. It was listed first in the Atlantic Charter by Franklin Roosevelt and Winston Churchill, so I would definitely be mentioning this if I was talking about the nature and development of self-determination. We do have free and fair elections and an operative system of independent government. However, in Australia with Atsi people, as I mentioned, we do not have self-determination like at all, which is something else that you would certainly want to make note of in your response. In terms of international responses, we have Article 1, Section 2 of the UN Charter and Article 15 of the UDHR. So why do I keep mentioning these international documents that source these human rights or discuss these human rights? Because I would recommend in legal studies, whenever you're responding to a human rights question about a particular right, always my next sentence after my first sentence would be, so first sentence would be me defining the human right. So let's say if I was asked about self-determination, my first sentence would be defining what self-determination is, saying that it's a collective right. And then my second sentence would be saying something along the lines of self-determination is covered under international law, specifically under Article 1, Section 2 of the UN Charter and Article 15 of the UDHR. Always, always, always where you can, state where we can find in international law and domestic law, if possible, the protection of a given human right, whatever the one that you're looking at is. Okay, so environmental rights now. environmental rights is not a formally recognized right. Okay, what does that mean? We don't actually have it explicitly in the UDHR, ICCPR, ICSCR, or the UN Charter, right? The formal documents or formal statements of human rights. However, there is obviously an increasing agreement that future generations have a right to enjoy the same level of environmental quality as the present generation. Okay, so this is the idea of intergenerational equality, that our future generations deserve to have the same access to the environment that we do. The displacement of people, so climate refugees, is viewed as a major human rights issue and a major breach of environmental rights. Environmental refugees are not recognized in international law. So the 1951 Geneva Convention relating to the status of refugees only protects those feeling persecution, war, or violence. I'm pretty sure I meant to write there fleeing persecution, war, or violence. Okay, so environmental law doesn't cover international law doesn't cover environmental refugees, which is a big limitation of international law. But we have had some responses to environmental rights, starting with Kyoto Protocol of 1998, Rio Declaration of 1992, and the Paris Agreement, which is arguably the largest response to environmental rights of 2016. Okay, which was the first universal, legally binding global climate deal. It aimed to bring, or it continues to aim because it's still kind of a work in progress, global warming down to reduce well below 2 degrees, okay, which is when we know if it goes above 2 degrees, the global temperature, if it rises above that, habitats start being kind of really threatened. Another modern response is the Australian versus Japan whaling case, where Australia basically took Japan to the ICJ for whaling in Australian waters, okay, which obviously whaling, literally fishing for whales, is illegal under Australian domestic law. So Japan, being in Australian territory, whaling is illegal, okay? And Japan had to immediately stop that. And that was good for environmental rights because obviously it relates to that idea of intergenerational equity. If we're able to have access to and see and experience life with whales, future generations should as well. Okay. Peace rights now. Moving on to peace rights. Peace rights is the right of people to have their government maintain peace and eliminate war. So in ancient times, countries acted in their own interests and the international order was determined by the dominant state. Okay, so if I'm the Roman Empire, I don't care about the rules of law or peace rights. I just want to go and start war and take over this land and that land. Okay, so that's more an ancient civilization. But since then, we've had really new deadly weapons created. So the idea of peace rights has become really, really important because now we have the potential to kill people, but also kill humanity at large. So rules for waging war were developed through international conferences and meetings to try to govern, especially nuclear warfare, because it's kind of immense threat to humankind at large. Okay, now, peace rights are really easy to talk about because, remember, the UN was established post-World War II to try and create and maintain global peace and security. So peace rights basically started at the genesis, or with the genesis of the United Nations. The Charter does permit military force and self-defense. Okay, so this is the concept of war on terror that has been justified. That justifies war on terror. So fighting back against terrorism, it's the idea of self-defense. If a state commences an illegal war, it is considered an act of aggression and parties involved can be tried by the International Criminal Court. Okay, so these are examples. We're not going to go through all of them, but I'll go through peacekeeping missions. But these are some examples of things that you could talk about if you're talking about the developing recognition of peace rights. Now, do not need to know all of them, but I would definitely talk about peacekeeping missions because I think they're literally designed to respect peace rights. So peacekeeping missions basically is where the UN can send in a group to fight back at the country that's having conflict. Let's say there is a particular country that's having conflict and there's war going on, civil war in between different groups in the country. They can send in a peacekeeping mission to basically use conflict to try and stop the war. And it's kind of all designed to keep the peace, even though we are using war to try and stop war. It's kind of aimed towards ultimately stopping warfare. Okay, so now we're going to look at the different sources of international law and how it kind of comes to influence domestic laws. So we know we had before this the UN Charter of Rights, the UN Charter 1945, which kind of created the UN, so imagine that's here. From there, though, the biggest thing was the UDHR, the Universal Declaration of Human Rights. This was the first time we had a large-scale global definition and recognition of human rights, okay? However, remember, the UDHR wasn't enforceable. Countries didn't ratify it and also, in Australia's case, enact it. Because remember, Australia doesn't only need to ratify a treaty, it needs to ratify and then also enact it for it to become a part of our domestic legislation. So, from there, we made the ICCPR and the ICSCR, which gave rise to different other multilateral and bilateral treaties, which then have become domestic legislation. Okay, so you can see how the UDHR really was the initial step or the initial stepping stone toward further not only promotion but enforcement of human rights. So if you're asked about the influence of the UDHR or a formal statement of human rights on the development of human rights, I would pick the UDHR and basically outline that while it wasn't enforceable, it gave rise to enforceable pieces of legislation, which definitely have had an effect in a significant amount of states. Potentially not all states, well, actually not all states. As I said, we know China doesn't respect some human rights. However, that doesn't necessarily mean that the ICCPR, the ICSCR, and the UDHR are irrelevant and didn't have any good effect. They still had a very significant good effect. They were limited in some regard, though. Okay, so looking at all of these more specifically, the UDHR, as I said, came after the UN Charter 1945. It was drawn up in 1948 following the establishment of the UN, as I said. Human rights have always existed, but only applied in esoteric and narrow capacities. Okay, so states basically didn't really recognize human rights. However, after the atrocities of World War I and World War II, it served as a catalyst for us all to come together and say, all right, we actually really need to protect human rights. Unlike the UN Charter 1945, the UDHR specifically defined all our human rights and freedoms. We voted on the UNGA and from its inception has brought together expressions of a wide range of rights. So the UN General Assembly, okay, where all states come together and basically work towards solving global human rights breaches. Okay, so these are the different areas that the UDHR protects. So life, liberty, thought and expression, religion, education and work. And it has now become international customary law because it's not binding. Okay, the effectiveness is that it carries enormous moral weight. It's adopted by the majority of the international community. The fact that the UDHR is soft law encouraged the maximum number of countries to sign up, meaning that because there wasn't really an onus on these countries to necessarily enact this legislation in their own domestic legislation, they were quick to say, yeah, we'll join. And it's an aspirational declaration, okay? It's something to work towards because obviously in a lot of places, human rights aren't fully protected. And areas of ineffectiveness is that, as I said, it isn't technically legally binding. It's considered soft law. Okay, the twin covenants, okay? ICCPR, ICSCR. They were developed in 1966, but they didn't come into force until 1976. They were established to enforce the rights in the UDHR and make it legally binding on nation states. The Twin Covenants are considered as hard law because they're binding. It's a binding treaty, and with the UDHR, ICCPR, ICSCR, and the UN Charter, we make up the International Bill of Rights. Okay, so areas of effectiveness for these twin covenants. They've inspired over 200 international treaties and conventions. Don't underestimate that, okay? I know it's just one dot point and you can think, oh, okay, just one dot point. That is a significant achievement. They are binding and enforceable, and they have been enforced in many states, okay, which have protected many people from human rights breaches. Ineffectiveness, though. The notion of human rights are sometimes said to be Eurocentric. So we kind of need to work towards the idea that human rights should not be culturally specific. So the definition of human rights in the UDHR, is sometimes criticized in that it's Eurocentric, and human rights, or things that we believe to be human rights in more Western countries, aren't necessarily seen to be human rights in Eastern countries, and vice versa. State sovereignty still stands in the way of international law being truly enforceable. Remember, state sovereignty is the idea that a state can make laws and rules regarding its own property and its own people without external interference, okay? Which of course stands in the way of enforcement of human rights and the effectiveness of the ICCPR and the ICSCR, because states can choose to not enact it or not ratify it, or they can choose to ratify it but not agree to it. And a lot of the time, nothing really is done. The power of veto that exists in the UN Security Council limits efforts to enforce these covenants, because a lot of the time when there's a conflict happening, certain states with veto power, so remember that's France, the US, England, China, and Russia, one of them will veto it. For example, in the Syrian conflict, China and Russia vetoed taking any power against it, because that was kind of at odds with their financial gain they got from that conflict. Okay, so the ICCPR has to do with civil and political rights, such as the right to life, freedom of religion, freedom of speech, freedom of assembly, and the right to a fair trial. It has the aim of protecting people from the arbitrary use of government power, so authoritarianism or totalitarianism. Governments can't just come and suppress your rights. They're first generation rights, and 172 countries have signed, excluding China and Saudi Arabia. Okay. So countries can pick parts they don't follow or they don't agree in following. Okay. What does this mean? Basically, we have revisions of the ICCPR for every state, meaning that if Australia gets the ICCPR and they say, all right, we like this, we can agree to all these human rights, but we don't want to protect that human right. They can basically agree to everything else in the ICCPR, but not that right, okay? Which sounds a bit crazy because it's like, why wouldn't you protect all the human rights? But the idea of the UN in allowing this is at least the other rights will still be protected. Of course, it's still bad that we're able to have provisions where certain human rights are taken out and aren't ratified into domestic law. It still enables the protection of some human rights, okay? So the big issue with human rights in Australia, one of the big issues, we have two. We have two main ones. Firstly, we have the rights of Indigenous people that need to be protected more strongly, such as increased self-determination, okay, or increased protection of self-determination. And then the other one is torture, okay? So Australia has detention centres where basically people who, a lot of people who, like people, smugglers and things like that, they're fleeing conflict or environmental crises, and they arrive in boats to Australia. Australia basically will send these people to detention centres. And oftentimes, most of the time, 99.999% of the time, these detention centres have very, very, very horrible conditions, like extremely horrible. A few years ago, a man, I believe, set himself on fire to kind of send a message of how bad life is in these detention centres, okay? And Australia has been heavily criticised for not protecting those people's human rights and, in fact, breaching their human rights by forcing them to live in such horrible conditions. There are even quotes of these people outright saying that they wouldn't have come because living in these detention centres is worse than living back home, which is horrible. Okay, now the ICSCR, this has to do with economic, social, and cultural rights. Okay, so the right to work in jobs that are freely chosen or accepted, the right to remuneration, I'm not even going to try and repronounce that allows a decent living, the right to form and join trade unions, the right to social security. It has the aim of upholding people's quality of life and livelihood. It's a second generation right, meaning that you need political rights first to be able to develop your economic, social, and cultural rights. 160 countries have signed. China, again, Saudi Arabia have not. Also, Singapore has not. And it's monitored by the UN Committee on Economic, Social, and Cultural Rights. Okay, so this is something that I thought I would include in here as a little practice question that you could do, or maybe like a thought bubble and just kind of brainstorm your response in your own time. But it's a nice question to get us thinking about how we can apply everything we just went over. So, in your opinion, how and to what extent have these major international documents contributed to the modern day development of human rights? Okay, so UDHR, UN Charter of 1945, ICCPR, ICSCR. It's a good little revision activity for what we've just done. Okay, so I'm going to take a big sip of water so my voice doesn't just run out. And we're going to start topic 2, which is the promotion and enforcement of human rights. Okay, so as I said, this is what we're going to be looking at from the syllabus. So in particular, we're going to look at in the international community. Remember, as I said, what is a state? A state is an independent country, defined territory with a permanent population and an effective government. Okay, so that's the idea of a state, almost synonymous with country. What is sovereignty? It's the power to make your own decisions without external interference. So, state sovereignty means that international law is unable to interfere with what happens within the state without the state's consent. All right, so the UN Charter strengthened the existing international system based on the sovereign equality of the states so as to protect states from unwanted violent intervention from antagonistic external forces and, by extension, protect the human rights of citizens. Okay, so this is an idea that makes state sovereignty good, okay? Particularly that this idea of antagonistic states can't just declare war left, right, and center when they feel that they need to protect the citizens' human rights. Oftentimes they don't even want to protect human rights if they have ulterior motives. But nonetheless, that's something that was good about this idea of state sovereignty that was outlined in the UN Charter, okay? However, as evidence, sovereign states are also determining the process and the nature of the implementation or non-implementation of human rights. So basically, state sovereignty empowers states to breach human rights and to not protect human rights. An idea that I want to just quickly capture here is that just because a state has legislation protecting a human right doesn't necessarily mean that it's protecting the human right. That might sound a bit confusing, but let me explain. So let's say I live in country X. Country X has a law on every single human right. But let's say I'm a citizen of country X and I go to the government and say, hey, I was forced into slavery for 2 years. And then the government says to me, okay, whatever. Does that mean that that country or that state has actually protected my right or my freedom from slavery? No. Okay. So just because a country has human right legislation or legislation protecting human rights doesn't actually mean they're protecting human rights. How do we actually know that a state is protecting human rights then? Compliance. Are they complying to their own domestic legislation and international obligations from the treaties they've ratified? Okay. And in the case of Australia, ratified and enacted. So things like R versus Wei Tang tell us that Australia is compliant to the Commonwealth Criminal Code Section 270, okay? Because they were quick to sentence Wei Tang and quick to send out the message that no, Australia will not tolerate cases of slavery and the breaches of freedom from slavery, okay? Which tells us that for slavery, Australia is pretty compliant, okay? All right. So state sovereignty creates major issues when human rights breaches occur, okay? Because it's almost like they can just kind of do what they want, and the external international committee can't really do anything about it. The fundamental principle of international law is that no nation state can interfere in the domestic affairs of another nation state unless authorized by the UN. So this is under the responsibility to protect, okay? That we have a responsibility to protect our own citizens, but also the citizens of other states. However, the UN has experienced extreme weakness in enforcing its decisions on human rights due to state sovereignty and veto power, as I said. And the example there is what I was talking about earlier, veto powers specifically that were used by Russia and China in Syria. One way to promote human rights is to automatically make international law domestic law, as they do in Belgium, France, Germany, and Austria. So as soon as international law is signed and ratified, it immediately becomes a part of domestic law. The Netherlands has gone one step further, having international treaties ratified into their constitution, which is, of course, good. Okay, so areas of effectiveness and ineffectiveness for state sovereignty. Firstly, states can exercise influence in international forums. Okay, this means that if a state chooses to use state sovereignty for good, because remember, state sovereignty isn't always a bad thing. For example, Australia uses state sovereignty for good to protect human rights. It uses their ability to govern their own people to protect those human rights. And this can influence the wider international community to also protect those human rights. States can impose sanctions on other states for breaches of human rights. So this was seen particularly in the Russian-Ukrainian conflict. When Russia chose to go into Ukraine, invade Ukraine, a lot of states, including Australia, sanctioned particular trades with Russia as kind of a sign to stop, or in a way to punish them. So if a state is starting a war with another state, the surrounding states can choose to not trade with them as a kind of punishment. States can implement domestic laws protecting human rights, as I said, and that's really good, obviously, for the people. However, states can ignore international human rights. States can enact discriminatory laws and engage in repressive practices. States can remove existing domestic human rights protections, and states can ignore domestic human rights violations. Yeah, effectively, state sovereignty either gives states the power to be really good or be really bad. Gives them the power to do whatever they would like, okay? So another kind of practice question that you can do to start getting you thinking is this one here. When it comes to human rights, is state sovereignty beneficial or has it proved to be more of a hindrance? Discuss. What do we think? Okay, so the United Nations now. The United Nations is the world's largest and most widely recognized intergovernmental organization. Not to be confused with an NGO, okay, a non-governmental organization. Remember, it's an IGO, meaning intergovernmental, different governments are coming together to work together. It is a chief organization involved with international law, as we kind of have figured out by now. As I said, it was established under the UN Charter in 1945, and it was comprised of several UN organs, including General Assembly. So the General Assembly is like the Parliament of Nations, right? It's the image of the UN that we all have, that big room where they all kind of come meet together and sit together and vote and discuss particular human rights breaches and issues. It has 193 members. It consists of representatives from all member states with equal voting power. It's the main forum for international discussions, deliberations, declarations, and recommendations relating to human rights, as I said. Each member has only one vote. Now, that has been criticized because people think should states with a population of 1 million have the same or equal value of their vote to states with, I don't know, billions of people? Should they only have one vote each, or should, you have one vote per 10 million people you have in your population? Equal voting power in international discussions, declarations, and recommendations, okay? The good of that is that, there's equal voting power. So that means that marginalized or often, marginalized states or states that aren't as powerful or dominant as others aren't kind of quieted by more powerful and dominant states, okay? All right, so the responsibility to protect. For those of you who are doing World Order, you will look at this in greater detail in that elective, but this is kind of an introduction to it, and for everyone else, we still need to know this principle. So, the responsibility to protect forefronts the protection of human rights as an integral part of responsibility that goes with being a sovereign state. It has 3 pillars. Firstly, that states' responsibility to protect their population from international crimes. Secondly, that it's the state's responsibility to assist other states to build their own capacity to protect human rights. And thirdly, the responsibility to take action when a state has failed to protect their population. Okay, so if Australia is not protecting our human rights, other states carry the onus or carry the responsibility to protect our human rights. For example, in Syria, the US invaded in 2003 as ISIS was accused of countless human rights breaches, and the Syrian government weren't acting against it, so the UN, under the responsibility to protect, invaded Syria. Okay, we also have the Security Council, which is another organ or part of the UN. It has 15 members, 5 are permanent: US, UK, China, Russia, and France. Yes, okay, there are 5 there. Sorry, I was thinking, did I only put 4? 5. 10 other countries elected for 2-year tenures. So on a cycle of 2 years, Australia might be a part of the Security Council, and then someone else is voted in. It's charged with the preservation of international peace and security. It exercises its power through legally binding resolutions and can authorize military sanctions, actions, or peacekeeping operations. The 5 permanent members have the power to veto decisions, so say, nope, this is not happening. And if they vote no, it's not going ahead. And they have the power to send peacekeepers. Okay, so if the other 10 members say no, that doesn't necessarily mean that the decision's not going ahead. That will only be the case if they have a majority no vote. But if everyone else says yes, and then China, for example, says no, it's not going ahead. They have veto power. Okay, there's also the UN Secretariat, which provides the various information, studies, tasks, and facilities needed by the UN. So it's doing all the kind of information gathering. And then we also have the International Court of Justice, or the ICJ, which has it's the UN's primary judicial organ. It has jurisdiction under the UN Charter to settle international disputes submitted to it by member states and produce advisory opinions on matters of international law. Okay, so basically Australia versus Japan, as I was talking about before, they would have come to the ICJ for settlement regarding whaling in Australian waters. Yeah, as it mentions there. Okay, and then we also have the UN Human Rights Council. Its main purpose is to promote and protect human rights by investigating and exposing human rights breaches, and then producing reports and recommendations. So a good example of this is annually it releases reports on retentionist states. What's a retentionist state? A state that still uses capital punishment or the death penalty. Okay, so it produces reports on the amount of times that they use the death penalty in that state. So China in 2020, I believe, used the death penalty over 1,000 times. Okay, and that was reported in the UN Human Rights Council report for that year. Why does it do this? Well, the aim of naming and shaming. Okay, it kind of follows the idea that if you name and shame a state for its use of capital punishment, the state will be more likely to prohibit the use of capital punishment domestically. Is this the case with China? Probably not, because China does not really care. It uses the most cases of capital punishment globally. Nonetheless, the UN Human Rights Council has 47 members that are elected by the General Assembly. It allows for a procedure for complaints by individuals with breached human rights. It conducts reviews of the human rights situation in all 193 member states. An advisory committee provides expertise and advice. It has been condemned unlawful. Ban Ki-moon, 2007, says that all victims of human rights abuses should be able to look to the Human Rights Council as a forum and springboard for action. Yeah, so it's designed as an organ, a springboard for action, to actually materialize change for human rights. Australia is a member, yet countries are critical of Australia's election due to inhumane treatments of refugees, as I was saying, in detention centres, at-sea incarceration rates, homelessness, and our strict terrorism laws. Okay, so the United Nations, its areas of effectiveness and ineffectiveness. Okay, you need to know this. Firstly, it's effective because it's kind of published the International Bill of Rights, right? UN Charter, ICCPR, ICSCR, UDHR, right? This has then catapulted into the publication of other treaties that have protected other human rights, or have been more specific on particular human rights, which again is a really massive thing, because think about how many states have been influenced by these treaties, have actually enacted these legislations into their own domestic legislation. Then we have the UN Summit 2005, which introduced the responsibility to protect doctrine, which is a really massive thing and really helps with protecting human rights and responding to human rights breaches. We also have the promotion of environmental rights, which is becoming increasingly more important, such as we saw in the Paris Agreement that we spoke about earlier. The UN Millennium Development Goals as well. So the UN, those are kind of the areas of effectiveness. The biggest area of effectiveness is, I would argue, the Bill of Rights. Could also talk about peacekeeping missions as well. There's an array of things to talk about. Areas of ineffectiveness though. Certain countries that are signatories to the UN continue to dispute the notion of human rights and believe it is up to the state to decide on the rights of their people, such as China. Okay, veto power has also been criticized because it regularly stands in the way of aims of the UN summit. Okay, as I said, Syrian conflict, the UN wanted to do something about it. China and Russia vetoed that decision. Nothing was done. The powers of the P5, all with nuclear weapons. So there we're talking about, again, China, Russia, France, England, and the US. In the UN Security Council go unchecked. Okay, so because they have veto power, there's no one kind of checking them and performing those checks and balances. And again, it's been critiqued for being Eurocentric, okay? The UN, has been critiqued for being Eurocentric and not considering non-European ideas of human rights and protecting human rights. Okay, so intergovernmental organizations now, moving to the next dot point. The two 1 and 2. I don't know why it says 1 and 1, but the two that you can look at are the UN and the Commonwealth of Nations. Those are kind of the two biggest ones. There are others, of course, but Commonwealth of Nations we're going to look at. The UN we already looked at, of course, we just spent time looking at. So if you were asked about intergovernmental organization, I would probably go for the UN because we've just spent so much time about it and you look at it in such great detail. But we can also look at the Commonwealth of Nations. It has 54 members, okay? It operates within the framework outlined in the Singapore Declaration of Commonwealth Principles, which is cooperating in the common interests of their peoples and in the promotion of international understanding and world peace, okay? So those are the aims of the Commonwealth of Nations. Its stated aims include the promotion of democracy, the rule of law, human rights, individual liberty, and good governance. Okay, another intergovernmental organization. All right, so the Commonwealth of Nations is second only to the UN in terms of its diversity, global renown, and longevity. It brings a wide range of worldviews and understandings that help to piece together what is fundamentally a universal right, and it's heightening its openness and transparency amongst the global community. Okay, so we can also look at the Commonwealth of Nations. Okay, we can also look at the African Union as another IGO, which has 55 member states. It launched in 2002. It has the Constitutive Act of the African Union, which sets out the aims of the African Union. The two largest, not all of them, but the two largest being that it encourages international cooperation, it promotes peace, security, and stability on the continent, okay? It has attempted to address the prevalence of child soldiers in Africa. For those of you who may have looked at that as your contemporary issues, you would be aware of kind of just the predominance of that issue in Africa, unfortunately. They have condemned Gaddafi's rule in Libya and supported the 1970 resolution of no-fly zone due to his crimes against humanity. Okay, so the African Union is another IGO that you can look at. Another one is the Arab League, which was founded in 1945. It has 22 members, okay, so not quite as large as, obviously not the UN, the Commonwealth or African Union, but Syria's membership has been suspended since 2011. Its main goal is to draw closer the relations between member states and coordinate collaboration between them. Economic sanctions have isolated Assad's regime due to human rights breaches. Okay, so these are kind of an array of intergovernmental organizations that you can look at. Now, would I say to only look at the UN? No, because I have seen questions where they specifically state will specifically ask you to look at an IGO that's not the UN. So it's important that you know of at least one that's not the UN. Okay, now looking at courts and tribunals in the international community. Let's have a look at the International Court of Justice. As I said, it's an organ of the UN. Australia versus Japan, 2010, I want to say, is an example of a case. Basically, it hears legal disputes between nation states, okay? It defines and interprets international conventions. State sovereignty means parties are not obliged to comply with the ruling, okay, which is perhaps its biggest limitation. Japan didn't have to stop, okay? Japan has state sovereignty. Japan doesn't necessarily have to agree with what the ICJ says. It has limited jurisdiction. Another massive limitation is this next idea. It requires the consent of state parties to hear matters. So Australia and Japan had to consent to actually having the case, like being involved in the case in the ICJ, which you can see is a pretty big limitation because how frequently does someone want to be on trial and will consent to that trial? So it requires a significant degree of accountability from the states. They're unable to hear cases brought by individuals or by private organizations. Okay, it's between states. Okay, International Criminal Court now. The International Criminal Court has jurisdiction over crimes against the international community. Okay, so the way I remember the International Court of Justice and differentiate it from the International Criminal Court is the ICJ. We'll start with the ICC. The ICC, I think criminal court, okay, crime. And then I think, okay, Transnational crime, no. Crimes against the international community. Okay, I relate it to the dot points in crime. Think about your international crime dot point in the crime module unit. Think about the types of crime. Transnational crime, no. Crimes against the international community. So then I think, okay, if that one's against the international community, then this one is the one that deals with disputes between states. Okay, so let's look at the ICC. The ICC has jurisdiction over crimes against the international community, as I said. So these include things like genocide and war crimes. It was created by the Rome Statute of 1998, which was ratified in 2002 in Australia under the International Criminal Court Act 2002 Commonwealth. The case must have been either referred by the UN Security Council or allegedly committed in a territory of an ICC member state. Now, this next idea I really want to hone in on. It is a court of last resort, okay? It will only hear cases if the nation state investigating the crime is not genuine or is unwilling to do so, or they do not have the resources to do so. So, slavery is a crime against the international community. Okay, we know that. So then why wasn't Wei Tang tried in the International Criminal Court? Well, she wasn't tried in the International Criminal Court because Australia was able to respond. Australia was able to try her and punish her, okay? So the ICC will only do its thing when the domestic response hasn't been suffice or there has been no domestic response. Okay, so only 118 nations have both signed and ratified the Rome Statute. USA and Syria are among the countries who have not. Now, if you have not signed and ratified the Rome Statute, the ICC can't try people who commit crimes against the international community in those states. So, for example, President Assad cannot be brought to stand trial. Russia has veto power as well, okay, which can prohibit Russia being tried at the ICC. The biggest critique for the ICC is that it's expensive. Its annual budget is only $100 million, okay? But you'll see that to get convictions, it will way blow over that. So, for example, Forbes in 2014 reported that in 12 years, they spent $1 billion, okay, which is much higher than the annual budget. I know that's for 12 years, but even still, that's much higher than the annual budget, particularly for only 2 convictions, okay? $1 billion is, very, very expensive, very slow as well. The biggest critique is that it's resource inefficient. Slow, it's very costly. So whilst it is resource efficient and its convictions are few and far between, the ICC is still an important mechanism for its effectiveness at protecting and raising regard for human rights at the international level. But I would still say that it's very ineffective because it's very costly and very slow. Now, Thomas Lubanga, 2012, is an example of a case you can refer to for the ICC. He was found guilty of conscripting child soldiers in the Congo and sentenced to 14 years imprisonment. Okay, we also have ad hoc tribunals. What does ad hoc mean? Well, it means for this purpose. So the tribunals are set up for particular purposes, okay? So we had an ad hoc tribunal for the former Yugoslavia. We had an ad hoc tribunal for Rwanda that was set up to only deal with those specific breaches of crimes against the international community. That allows for specialization and a greater familiarity of the conflict. They are aiming to be resource efficient and quick. They are in practice not really though. So let's have a look at the International Criminal Tribunal for Rwanda that was set up particularly for Rwanda only. It targeted genocide and other serious violations of humanitarian law in Rwanda. It estimated that 800,000 to 1 million Tutsis and Hutus were killed from April to July 1994. So those are the two kind of groups that were embarking in war against one another. The International Criminal Tribunal for Rwanda indicted 84 individuals, 72 completed trials, and we had 62 convictions, such as the prosecutor versus Akayesu, I really hope I'm not butchering that, who got life imprisonment. They're currently in the process of finalizing their operations, okay? That was in 1994. So you can see what I mean about resource inefficient. It's taken them almost 20 years to, actually almost 30 years to finalize their operations. Okay, so kind of incredible. All right, so let's now look at, in Australia, independent statutory bodies that regulate the protection of human rights in Australia. Australian Human Rights Commission, okay? If you're asked about independent statutory authority, this is who you want to be talking about. It was established under the Australian Human Rights Commission Act 1986 Commonwealth. It monitors the compliance of Australia fulfilling human rights obligations. It provides legal advice to courts. It makes submissions to parliaments and governments regarding breaches of human rights and levels of compliance to human rights. And it initiates research into human rights and discrimination issues, such as we saw with the Bringing Them Home report, okay? They reported on the statistics and the issues related to the stolen generation. Now, this is a hallmark of a democracy. An independent statutory authority that ensures the state is complying to human rights, domestic legislation, and international obligations. If we didn't have this body, this body holds Australia accountable. If there's a human rights breach, you'll know. The AHRC will be the first one to kind of critique the human rights breach. So democracies, states that protect human rights, are states with independent statutory authorities like the AHRC. Okay, so non-government organizations. Obviously, a non-government organization is an organization that works independent from the government, okay? It has nothing to do with the government. They're an agency for reform, okay? They put pressure on the government to act and to increasingly respect human rights and, protect human rights. They help ensure greater government compliance to human rights, as I said, by investigating, documenting, and publicizing cases of human rights violations, naming and shaming, raising awareness through media campaigns. They may provide evidence to international courts and lobbying other states to apply diplomatic pressure or take action against violating states. Now, those first two are more indirect promoting of human rights, okay, indirect. And the last two are direct. What's the difference? Direct is going and doing action, whereas indirect is more naming and shaming and influencing public opinion and making the public more aware, whereas direct is getting the action. Okay, as I said, they apply moral pressure for governments to comply with and uphold human rights. They promote, not enforce. A large group of students every year always say that non-government organizations are ineffective in protecting human rights because they're really good at promoting, however, they're terrible at enforcing. Is that their aim? Are they designed to enforce human rights? No. They're designed to promote human rights. We have bodies that promote human rights and we have bodies that enforce human rights. NGOs are responsible for promoting human rights. Okay, they're not needed to enforce human rights, or they're not responsible for that. So only judge it by its aims, not by its ability to enforce human rights. You can still say that whilst they cannot enforce human rights, that is not their aim. That is not their designed purpose. Okay, in fact, I would be saying that. Okay, so we have Amnesty, UNICEF as some examples, and we have the International Committee of the Red Cross, another example. Since 1990, it has been an observer at the UN General Assembly, the International Committee of the Red Cross. Okay, so the main non-legal vehicle for naming and shaming governments and human rights abuses that happen on their watch is the media. Okay, it's the role of the media to investigate, report, and expose. The growth of 24-hour news channels and the internet means global news is more accessible for consumers and publishers than ever before. Is this necessarily a good thing, though? Is it good that we have 24-hour news, that we're kind of bombarded with all these different aspects of life, including breaches of human rights, okay? Now, the big note that I want to make here is that the media We need to have the media for a democracy, believe it or not. We need to have things other than the government that are able to critique the government. We need to have a critique of the government, okay? Now, Sky News or Fox are usually more on the right wing, and ABC, maybe SBS, more on the left wing, okay? Now, it's good that we have both. Even if you're someone that falls more on the left wing of politics or someone that falls more right wing or more neutral, it's good that we have both. Why? Because we need to swing the pendulum. We need people with these kinds of views to critique people with these kinds of views, to critique people with those kinds of views. So we get good discussion, and so we're able to have checks and balances for each other. Because in places like North Korea, where the government is essentially running the media, no one can critique the government. If the government is doing something that's really immoral or corrupt or breaching human rights, there is no one to come out against it. Whereas if something that people who are of the Liberal Party or align themselves with the Liberal Party, they don't recognize something as an issue, Labour, the people of the Labour Party will certainly come out and swing the pendulum and say, no, we recognise that this is an issue, okay? It's good. It's actually good to have that discourse, okay? It's good to have as many different perspectives and opinions. Why? Because that's how we protect human rights. That's how we get someone saying, hold on, you're not protecting human rights. Hold on, this is a breach. Hold on, how will this affect these groups? Okay, which is really good. So this is an example of some Australian media here. Here are some example of global media companies there. Okay, so areas of effectiveness and ineffectiveness for the media. Firstly, there are less hoops to jump through to expose human rights violations, okay? There's less kind of muddle for the average person to understand human rights. The media oftentimes dumbs it down a lot, which is good because it allows us to understand it, but also can oversimplify things and not capture the full complexity of human rights issues. We also can suffer from compassion fatigue, which is when we over-consume human rights breaches and really awful things happening around the world and become fatigued with how much compassion we're having to spill out. It's a platform for minority groups to voice the human rights breaches. We do have the spread of fake news and the spread of misinformation. And we have recently seen the degradation of journalistic integrity, okay? And that kind of aligns with that idea of spreading of fake news and misinformation. Okay, in 2018, the World Press Freedom Index ranked Australia at 19th globally. However, in 2019, Australia was 21st. Okay, so we've dropped down. But China sits at 177 and North Korea at 179. The media may exhibit political bias, as I said. They can be far right, neutral, far left on the political spectrum. And we have seen censorship of the media, okay, by sovereign states, such as in North Korea, as I was saying, which is prohibited under Article 19 of the UDHR. Okay, so promoting and enforcing rights in Australia. So there are 3 ways international human rights is incorporated into Australian domestic law. We have statute, common law, and the Constitution. Firstly, the Constitution was created in 1901 at Federation. The Constitution set out what Australian government was going to look like and how we would operate as a newly federated sovereign nation state. It introduced 2 fundamental concepts, the division of powers and the separation of powers. Now, the division of powers basically separated federal, state, and local councils and the different areas of law that they oversee and are responsible for, okay? This was good because it frees up the time of the federal government, so the federal government doesn't have to overlook everything, even things like, bin collection. That's more the responsibility of local council. So then federal governments can refer to and look at more important things like taxation, like immigration, those kinds of things. It also ensures considered and more effective responses to the needs of the unique locality. Okay, maybe we need certain roads to be fixed in certain suburbs, and that will be, you'll need to really listen to the local residents there, whereas the federal government may not be as in touch or aware of these issues. Okay, the separation of powers is our strongest defense to efforts made inside the government to take and control and degrade human rights or civil liberties in Australia. Okay, why? Because the legislature, right, which is the parliament, judiciary is obviously judges, common law, the executive are the ones that enforce the law, so the police, the military, the army, those kinds of groups. Let's say the legislature, the parliament, makes a really terrible piece of legislation and passes it, enacts it, that allows people to breach each other's human rights. The judiciary can come out and say, hold on a second, no, that's not right. We need to fix that, okay? And kind of critique the legislature because it's separate. It's a separate body. Whereas if they're together, they're kind of going to agree on the same thing. So if they mutually make kind of a really bad decision, or they pass a bad law, or pass down a bad precedent, there's no one that's going to critique it. Okay, so having the separation of the powers allows the judge to come out and critique parliament to critique judiciary, police to critique judge. You can see how it's going. Okay, this is the main principle of democracy. It's really, really important. Okay, the Constitution also contains 3 express protections for human rights. So the right to trial by jury, freedom of religion, and the right to property. That right to property basically says that the government can't just knock on your door and take your land and just say, all right, you have to like go live somewhere else now. Freedom of religion is that you can practice any religion that you would like without prosecution or persecution, and the right to trial by jury. Okay, those are the express rights. The Constitution literally states that you have those rights. The High Court has also found that implied rights exist in the Constitution. Okay, implied rights are not express rights, they're not written, but they're implied, they can be inferred. So the right to vote is an implied right. Freedom of political communication also is an implied right. Statute law now, moving on from the Constitution and how that protects human rights. Statute law also protects human rights by literally defining the human rights and saying that they cannot be breached, okay? Things like the Anti-Discrimination Act 1977 and the Australian Human Rights Commission Act 1986. Common law now. Common law is really important because it applies statute law to the unique circumstances of cases, okay? So let's say the Commonwealth Criminal Code, all it said was that slavery is someone in shackles who cannot eat or drink and is living in a dungeon, okay? Really random, but let's say that was the definition. In R v. Wei Tang, the judge would have had to apply that and said, all right, is that the definition of slavery in this case? Is this still slavery? And applied the statute law to the unique circumstances of R v. Wei Tang. Obviously, it was not what in that made up law that I just made, it was not that. So the judge would have had to kind of create new precedent about slavery. Now, that obviously isn't what the Commonwealth Criminal Code says, but I'm just saying, I'm trying to demonstrate that common law applies the principles of statutory law to the unique circumstances of case law, okay? And that's its biggest benefit, because statute law is usually very vague and ambiguous. Common law obviously has really specific nuances and intricacies and specifics for each case, where someone needs to kind of think, is this a breach of human rights? So it fills in the gaps that statutes don't cover. Things like the presumption of innocence, the right to a fair trial, and native title. It evolves independent from government and parliament, as I mentioned with the separation of powers, and it frequently draws from authoritative international documents, okay? For example, Justice Brennan remarked that international law was a legitimate and important influence on the common law, especially when international law declared the existence of universal human rights. Okay, yeah, so international law directly influences the decisions made in common law. Common law is also not fixed and can be rendered redundant by later statute. Okay, so statute statute legislation can override precedent as well. Okay, courts and tribunals now. We have the Australian Human Rights Commission. We mentioned the Australian Human Rights Commission. They're considered an independent authority that promotes and enforces human rights in Australia. We have the High Court, which sets precedents which are binding and final on all other courts. They overturn legislation that is unconstitutional. We have Roach v. Electoral Commissioner 2007 that upheld that all people, regardless of circumstance, have a right to vote. Justices do sometimes consider international documents or conventions where there is an absence in the domestic law. We also have Lange versus ABC 1997, which is a case where we saw the effectiveness of the media. So the ABC released a Four Corners episodes alleging corruption and bribery by the then New Zealand PM David Lange. Lange commenced defamation proceedings against the ABC, but the High Court said an implied freedom of political communication must exist in a society that is built upon democracy. So the media is able to critique the government. Lange just can't come out and say, I don't like this kind of defaming, these defaming accusations if he's a political figure. Okay, so a Charter of Rights. So a Charter or Bill of Rights is a highly significant document that enshrines a sovereign nation's human rights in law. Okay, basically outlines the human rights of a particular state. Several Western countries have a Bill of Rights, like the US, the UK, New Zealand. However, Australia does not have a Charter of Rights. Okay, Charter of Rights of sorts exists in some jurisdictions. But we don't have a national federal Charter of Rights. Now, I'm not going to go through all of these, but you do need to know arguments for and against having a Charter of Rights. I've seen plenty of questions asked about it. So, arguments for a Charter of Rights, well, we have high community support of a Charter of Rights. It protects the marginalized and disadvantaged. It could improve the quality and accountability of the government, or because it enhances accessibility. Okay, for the average person, understanding all of their human rights in Australia is a bit tricky because they have to go to the Constitution, then statute, then common law. Whereas a Charter of Rights basically simplifies it and says, these are all your rights. Arguments against having a Charter of Rights, though, basically, we don't really need it. There's nothing that pressing happening to the Australian people at the moment that really is calling upon us having a Charter of Rights. It also undermines tradition of parliamentary sovereignty, okay, in that the parliament makes statute about human rights and that they don't need a Charter of Rights. This idea of if it ain't broke, don't fix it. We don't really need it. All right, now we're moving on to some legal studies skills. All right, one of the best skills you can learn as a HSC student is understanding mark allocation, which means knowing what the mark is will give you marks for and what they won't give you marks for, okay? For example, if it's a discuss question, you need to talk about both the pros and the cons, okay? That's what discuss means. You can probably say, all right, it's a 6 marker, it's a discuss question, 3 and 3, 3 pros, 3 cons. It's important to become aware of that mark distribution as you're answering questions, okay? Because, for example, if I'm doing only pros, you can see I've only given myself 3 marks. Okay, so if we got the question, outline how international human rights are incorporated into Australian domestic law. 1 mark would be incorporated through common law precedents and courts. You would need to be talking about that. 1 mark, it's incorporated through legislation, and then 1 mark is through the Constitution, as we just looked at, okay? So let's say, sorry, I've just realized I put 1, 1, 1, but it's a 2 marker. Let's say 0, 3 ways, okay? Split that mark value 3 ways. And then that's where each of the marks would be for. You would need to cover common law, legislation, and the Constitution, okay? Without a doubt. Okay, Outline how trade unionism can protect labor rights. Well, 1 mark would be for defining trade unionism. Always, whenever you see a human right, you need to define it, okay? So 1 mark straight away is for defining trade unionism. 1 mark is for collective bargaining and the idea of how it actually works. And 1 mark is how they can provide legal advice to workers. So the 2 different functions of trade unions. Case law and an example would be really, really good and would guarantee you those marks. Okay, describe how the common law in Australia promotes and enforces human rights. Use an appropriate example to support your answer. Okay, 1 mark, if this is a 4 marker, 1 mark would be defining common law, okay? Again, it's a key piece of terminology. We need to define it. 1 mark would be for the promotion, 1 mark for the enforcement, and 1 mark for an example, all right? So you basically need to be able to work out the mark distribution. It helps you save time and be more concise. Because if you're going on and on about promotion and then don't touch enforcement, you could have spent, half a page on promotion. You've only guaranteed yourself 1 mark. So you need to be smart. You need to work out the mark distribution for each question. This goes on to me saying time is short, don't waste time, okay? The best way to do this as well is knowing your verb, okay? So if you're asked to compare, you need to show how things are similar or different. If you're asked to identify, you literally can dot point if you're asked to identify. If it says identify a human right enshrined in the Constitution, the right to trial by jury, you literally can just put that and it's a mark. However, if it's define or describe, different, okay? And you can see that if you were describing for an identify question, you're wasting time. Okay, we're not going to go through all of them. As I said, if it's discuss, you need to identify issues and provide points for, and, or against. That's the NESA term. It says for and or against. That's how NESA have defined discuss. However, I would say to always give for and against. So writing response that only says why we should have a Charter of Rights will only get you a maximum of half the marks. So you'll only get 3 marks, as I mentioned before. Okay, so explain means to relate cause and effect, make the relationship between things evident, provide why and or how. To promote is to raise public awareness of something and bring forward as an issue. Okay, so let's have a quick look at this response to this 3 marker. The Australian Human Rights Commission is a national institution that promotes human rights through awareness programs or campaigns dealing with human rights issues. Okay, so I've just outlined how they do it, well, through awareness programs and campaigns. In addition, the AHRC prepares and releases reports concerning human rights. Example, the Bringing Them Home report. Okay, I've also said again how they've done it, the releasing of reports. And then I've given an example, okay? I've also defined what the AHRC is, which is where one of those marks would have went. Okay, compare the contributions of common law and statute law in enforcing human rights. Well, common law, it's an avenue or appeal for people who feel that their human rights have been ignored, whereas statute law overrides common law. This, though, can mean human rights can be abused by an irresponsible government. And I'm not going to go through all of these, but effectively to compare is to draw the similarities and differences, okay, which is what we're doing here. Definition, I would say 1 mark, 0.5 is going to definition of common law, 0.5 is going to statute law, so that's 1 mark away, so now we're left with 6 marks. 3 would go to differences of common law, 3 to differences of statute law, okay? That's how I would kind of split it. Again, I would have a go at this question if I were you. I would in fact have a go at all of these questions. Now that we've broken them down, I would certainly use them as a study tool. Okay, so this is a response to this 7 marker. After you have a go at this question, here is something you can refer to. We're not going to go through it, but effectively, this is kind of a sample response. Okay, now on our final topic, we're going to go through some frequently asked questions. So something that I guarantee at least one of you have asked in the Slido is, what is the best way to study for legal studies? In my opinion, looking over notes is a no-go. looking over your notes and just reading them is not going to help you in legal studies. Having typical notes is a no-go. Really what you want to do, especially for the essays, so crime and your electives, is have essay plans, okay? If I were asked about sentencing and punishment, these are my arguments. If I were asked about young offenders, these would be my arguments. If I were asked about the criminal trial process, these would be my arguments. For every kind of question they could ask, for every section of the syllabus, I would have essay plans ready to go. What's an essay plan? The 3 arguments you would have, or 4, and the evidence you would have under each of those individual arguments. So if you're looking at the criminal trial process and you're looking at charge negotiation as one argument, or your evidence under charge negotiation, okay? And memorizing that evidence. And then practice, doing practice responses and getting feedback from your teacher, okay? That's the best way to study for legal studies. I know it's not what we want to hear because we don't like doing practice responses, because no one wants to do a practice response, but it's the best way to study for legal studies. Okay, where do I find good resources to study? atarnotes.com, HSC Matrix Education, your Facebook discussion group. I know that sounds a bit crazy, but you will, and I've mentioned this earlier in earlier legal studies lectures series, so apologies if this is the second or third time you've heard this, but throughout the year, someone will likely post a Google Drive, and the Google Drive will have a range of different resources for almost every subject. So I would keep an eye out for that on your Facebook discussion group. Another resource, or somewhere with good resources, is HSC. Okay, really just try to get your hands on as many resources as you can. It's never a good idea to just be like, oh yeah, I have enough resources. If you can get more resources, get them. They can only serve to help you. Okay, how many weeks should I be spending on legal studies? Of course, it depends on many factors, okay? If you have an upcoming assessment for another subject, if you have an upcoming legal studies assessment, if you're on term break, if you're in the middle of term, etc., it'll change, okay? But because we all want an answer, I know, and it's not good enough to say that initial answer, I'd probably say at this stage, 8 to 9 hours is a good amount per week to study for legal studies, sorry. Okay, to summarize then, as we approach the end of the lecture, firstly, always check for the ness of verb, okay? In terms of our key skills, always check for the verb that you're responding to. Always check for the mark worth and try to break down the distribution. Always define key terminology at the beginning of your response. Outline your criteria. So how are you actually coming to this evaluation of your argument? So if you're saying that, for example, Australia is not good at protecting human rights, for example, how are you measuring that? Introduce a criteria that allows you to measure that. So compliance. Through measuring Australia's compliance to its domestic legislation, we can see that Australia is not good at protecting human rights, for example. Have a criteria. That is something that I want you guys to take, not just from human rights, also for crime, also for your electives. No matter when you're writing, you always need a criteria. You always need to say and explain to your marker, how are you coming to this argument? How do you know that the ICJ isn't a good body for the enforcement of human rights? Is it resource efficiency? Is that how you're judging it? Is it its ability to reflect customary international law? What is it? Okay, a reminder that the best way to improve is practice. Oh, I know every time I say this, I can just imagine you guys are like, oh, yeah, we know. But honestly, it's the truth. That's really when it boils down to everything. Yeah, going through the content and memorizing was good for me, but I wouldn't have gotten a band 6 if I didn't do it the amount of practice that I did. Something that I definitely want to tell you guys about, begin memorizing sooner rather than later. Think, you're going to have to remember all the cases, all the statistics, all the legislation for human rights, also for crime, also for one elective, which is a 25 marker, so there's more, and then also for another elective. So you're going to have to memorize heaps of evidence, okay? I know because I had to memorize it. And I wish someone had told me, build up the memorizing. Start memorizing it throughout the year instead of kind of trying to push it around trials and then push it around the HSC. Start memorizing now. Before bed, just go through something that I used to do. I used to have Google Slides, and I would have, like, on one slide, I would have, young offender arguments. And then I'd have all my arguments and all the cases and legislation and statistic and all the evidence for each argument. And I would sit there, close my eyes and say, okay, this, and try to, like, name all my evidence. And then open my eyes. Okay, I forgot this. All right, I need to come back to this one. And kind of it would really help me memorize all my evidence. So I would definitely say, biggest tip I can give you, or one of the biggest tips, is memorize sooner rather than later. Also, use up your study periods or your free periods if you have them. Don't just use them to mess around. I know it's tempting, but I would do practice responses during those periods if I were you, because it's time that you're not doing a practice response at home. You're doing it in your free period. So it's think of it like it's taking away something you don't have to do at home, and instead you can watch Netflix or whatever. All right. So that is the end of our lecture for today. Thank you so much for everyone joining. I will be in Slido answering your questions. After, I will stay back answering your questions. So continue to ask any questions if you have them. But yeah, thank you so much for joining, everyone. I hope today was helpful. I hope you learned at least something. We'll have more lectures throughout the year. So I'm really keen on seeing everyone later in the year for other legal studies lectures, or even other lectures that aren't legal studies. Okay, cool. Thank you, everyone. I will see